admitted, it is constructively published to Your Honor and the jury.
Very well.
The defense requests permission to stand or sit while delivering openings, closings, directs, and cross-examinations.
That's exactly right.
The defense requests that time be paused while preparing to screen share an exhibit.
Okay. As long as they're done within a reasonable amount of time, that's fine.
And also, for the sake of expediency, the defense would request that all exhibits are granted on a good faith basis for truth and accuracy, and therefore not need be presented to opposing counsel prior to presenting them to the court.
That's
and we would clarify that if opposing counsel has concerns about the authenticity of an exhibit, they object accordingly.
That's fine. If you do have a copy of it nearby, it's best to hand a copy to the other side. Okay? If you have a copy.
I put the rosters in the chat.
Excuse me?
I said I put the copies of the rosters in the chat already.
Okay, thank you. All right, is the prosecution ready for trial?
Yes, Your Honor. Would you like us to introduce ourselves to
I would.
The...
Let me see if the other side is ready to proceed, and then I'll do that.
Yes, Your Honor.
And is the defense ready to proceed?
Yes, Your Honor.
Okay. And so if both of you and the witness would identify yourselves, that would be great.
Yes, Your Honor. Good morning, Your Honor, members of the jury, opposing counsel. My name is Anna Seaman, and today with my co-counsel, I represent the people of the state of Colorado versus Avery Becker. Today, I will be conducting the direct examination of Detective Markowitz, the cross-examination of Avery Becker, as well as delivering the closing argument. At this time, may my co-counsel introduce themselves.
Good morning. My name is Leah Dino. I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins. Thank you.
Thank you.
Good morning. My name is Thomas Daneza, and today I will be conducting the direct examination of Mr. Kyle Cusack, the cross-examination of Professor Blake Van Owen, as well as giving the opening statement. At this time, may our witnesses introduce themselves?
Yes, please.
Good morning, Your Honor. My name is Dirksen Brinkerhoff, and today I am Detective Jordan Markowitz.
Thank you.
Good morning. My name is Owen Holbrook, and I am Alex Cifuentes.
Thank you.
Good morning. My name is Michael Dudzik, and I am Kyle Cusack. Thank you, Your Honor.
Thank you. Anybody else? All right, so in the courtroom, we will have the opening statement participants, and the rest will turn off their cameras, as I understand it.
Your Honor, would you like the defense to introduce themselves as well?
Oh, I'm sorry. I thought you had. Go ahead, please.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Kai Wong, and today, along with my co-counsel, I will be representing Avery Becker in the matters of the state versus Avery Becker. I will be conducting the cross-examination of Miss Avery Becker, as well as the direct examination of Miss Avery Becker, as well as the cross-examination of Detective Jordan Markowitz. Permission for my co-counsel to introduce themselves.
Please.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Heidi Schmid, and today I will be conducting the direct examination of Professor Blake Van Owen, the cross-examination of Kyle Cusack, and delivering the opening statement.
Thank you.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Morgan Taylor, and today I will be conducting the direct examination of Mr. Taylor Perkins and the cross-examination of Mr. Alex Cifuentes, as well as delivering the closing statements. Permission for our witnesses to introduce themselves?
Please.
Good morning, Your Honor, members of the jury. My name is Paige Gillespie, and today I am Professor Blake Van Owen.
Good morning, Your Honor, members of the jury. My name is Annabelle Swenson, and today I am Avery Becker.
Good morning, Your Honor, members of the jury. My name is Nathan Trong, and today I am Taylor Perkins.
Okay, thank you very much. And is council ready to proceed with opening statement?
Yes, Your Honor.
Okay. And we'll have in the room, I understand it, the counsel for the prosecution that's doing opening, the attorney for the defense who will be giving opening statement.
Yes, Your Honor.
Okay, and we ready to go?
Yes, Your Honor. May I proceed?
All right. Go ahead.
Good morning, Your Honor. Opposing counsel, members of the jury. My name is Thomas Dineza, and today my co-counsel and I represent the people of the state of Colorado. Everyone has a breaking point, and we are here today because the defendant, Avery Becker, reached hers. On March 6, 2020, Ms. Becker broke into the home of Mackenzie Brackman, and while inside, stabbed and killed him. Mackenzie Brackman was an attorney. He spent his entire life fighting for justice. He was a coach. In his free time, he poured hours into teaching young students at Colorado High School what it means to be an attorney in a competition called mock trial. One of these students was Avery Becker. Avery Becker was part of the team for all 4 years of her high school. And during this time, Avery Becker really enjoyed mock trial, but unlike the other students, didn't have to put nearly as much time or attention into the competition. This lazy attitude towards mock trial led to a growing animosity between herself and Mackenzie Brackman. As this tension grew, Miss Becker began to crack. In a fit of rage, Miss Becker lashed out at her coach, damaging his car and causing her to get kicked off of the mock trial team. In Miss Becker's own words, she would get back at Brackman if it were the last thing she did. And on March 6th, Miss Becker reached her breaking point. Stabbed and killed Mr. Brackman. The prosecution will call 3 witnesses today. First, you'll hear from Detective Jordan Markowitz. Detective Markowitz was the head detective for today's case and will walk you through his investigation. He will not only tell you what occurred, but he will also tell you how we can place Miss Becker at the scene of the crime on March 6th. Next, you'll hear from Mr. Alex Cifuentes. Mr. Cifuentes will describe the tumultuous relationship that Mr. Brackman and Miss Becker had. He will also describe threatening text messages that Miss Becker sent in regards to Mr. Brackman just prior to his murder. Finally, you'll hear from Mr. Kyle Cusack. Mr. Cusack is a civilian consultant for the Denver Police Department and will walk you through his crime scene reconstruction of the case. He will not only give you an account of what accurately happened on the day of March 6th, but also further show how Ms. Becker is the one responsible. The defense will also call 3 witnesses to the stand. You will hear from the defendant themselves, Ms. Becker. Ms. Becker will describe what she says to have happened on the day of March 6th. She'll tell you a convenient story of how she was searching for her phone. However, you will hear that the same threat that Ms. Becker made towards Brackman in the text messages was repeated by Ms. Becker to her mother just prior to Mr. Brackman's death. The defense will also call Mr. Taylor Perkins to the stand. Mr. Perkins reports to be Becker's alibi. However, listen closely. Ms. Becker's only alibi is her lifelong best friend, who said himself that he would do anything for Ms. Becker. The defense will also call Professor Blake Van Owen to the stand. Professor Van Owen will walk you through his investigation of the crime. But listen carefully. All of Professor Van Owen's so-called evidence is inherently biased against the Denver Police Department. In addition, he himself neglected to investigate all of the possibilities of the case, likely fearing what he might find, the truth. Ms. Becker is being charged with first-degree murder and second-degree burglary. This means that Avery Becker unlawfully and knowingly broke into the home of Mr. Mackenzie Brackman and during the invasion, killed him. As the court will instruct you, Ms. Becker did not have to have the intent to kill Mr. Brackman, rather the intent to break into his home. After hearing all of the evidence for today's case, there will be no doubt that Ms. Becker intended to break into the home of Mackenzie Brackman. Avery Becker had reached her breaking point. The prosecution asks that at the close of the trial, you reach the only logical verdict. Guilty as charged. Thank you.
Counsel, thank you. Counsel for the defense, ready?
Yes, Your Honor. Good morning. My name is Heidi Schmid, and today I will be representing the defendant, Avery Becker. As you know, on March 6, 2020, Mackenzie Brackman was found dead in his residence. The prosecution is accusing Ms. Becker of murder. Today, you will meet Ms. Becker and you will learn through herself and her friends that she's just like any other teenager. In fact, on the day of the murder, she skipped school with her best friend, a normal teenage thing to do. The victim, Mackenzie Brackman, was her mock trial coach. Every person has had that one teacher whom you just didn't quite click with. Mackenzie Brackman was that for Avery Becker. Ms. Becker loved mock trial. Needless to say, high school is not exactly an easy environment, but mock trial was the one place where Avery Becker thrived. Many witnesses today will testify that Ms. Becker was good at mock trial as well, receiving awards for best attorney and best closer at regionals. Sadly, this came with repercussions because Mr. Brackman did not believe that Avery Becker deserved any of her well-earned awards. This scrutiny resulted in an argument between the coach and student. After this argument, feeling understandably angry and embarrassed, Avery Becker wrote on the victim's car. She wrote "Worst Attorney Award" with what she thought was a dry erase marker, a stupid teenage mistake. Think back to a time when your emotions got the best of you, and you might have said or done something that you regret. Avery Becker made that same mistake and is now being tried for murder. The incident prompted Ms. Becker's removal from the mock trial team. Taylor Perkins, Ms. Becker's best friend, then resigned from the team as well for moral support. After getting kicked off the team, Ms. Becker will tell you that she felt terrible, both for what she had done and because mock trial meant so much to her. Ms. Becker will testify that she did not jeopardize her chance of getting back on the team by doing anything to Mr. Brackman besides apologizing. However, Mr. Brackman wanted no part of her apologies, even after going to his office, texting him, and offering to pay for a paint job or scrub the marker off herself. Feeling discouraged that Thursday when Ms. Becker would have been at practice, she hung out with Mr. Perkins instead. They even saw other mock trial team members while getting dinner. Sometime that night, March 5th, 2020, Ms. Becker lost her phone, which prompted her to skip school on March 6th, 2020, to look for that phone with Mr. Perkins. The prosecution believes that Avery Becker's anger at Mr. Brackman led her to break into the residence of and ultimately kill him. However, the defense will prove that the prosecution came to this conclusion through corrupted evidence, lost suspects, and biases. You will hear from our expert, Blake Van Owen, that Avery Becker is now being charged of murder because the prosecution wanted to come to an easy conclusion. She will testify that to get to the easy conclusion, the police proceeded with a sloppy investigation, an investigation that blames a child who will testify that she laments her terrible relationship with Mr. Brackman. Avery Becker sure didn't like Mackenzie Brackman, but will attest that she was not there at the time of the murder, did not even know where he lived, and was with her best friend at the time. Today, you will hear from 3 defense witnesses. Again, Professor Van Owen, an expert in police practices, cell tower analysis, and crime scene reconstruction, who will discuss oversights, loopholes, and doubt in the prosecution's case. Taylor Perkins, the defendant's best friend, and again, who she was with at the time of the murder. And finally, Avery Becker, the defendant, who will testify to her side of the case. During this trial, please listen to the faults in the prosecution's case presented by the defense and think about how a teenager's future is at stake. By the end of this case, the defense will prove that there's too much doubt to convict this child, and that the prosecution came to this conclusion not because it was right, but because it was easy. Thank you.
Thank you, counsel. Is the prosecution ready to call their first witness?
Yes, Your Honor. The prosecution calls Detective Markowitz to the stand.
Okay. Detective Markowitz, do you?
Yes, Your Honor.
Hello. Do you promise the testimony you're about to give will faithfully and truthfully conform to your witness statements, that we will not add any material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Okay, thank you. Counsel?
Yes, Your Honor. Good afternoon. Please state your name and spell your last name for the record.
Yes, Jordan Markowitz, Markowitz.
And what do you do for a living?
Well, I'm a homicide detective for the Denver Police Department.
How long have you been working there?
I've been working for the DPD for around 13 years, but specifically, I've been a homicide detective for 7.
Do you have any other certifications or trainings?
I do. I have a certification in cell phone technology and forensic data reconstruction from the American Academy of Law Enforcement.
What did you have to do to get that?
I had to take a 3-day training course and then complete a high-level certification test.
Have you ever used this experience before?
Yes, I've used this certification as well as the Cellubrite system software in over 50 cases of detective work.
And were you asked to give an expert opinion in today's case?
Yes.
Your Honor, I now move to enter Detective Markowitz as an expert witness in the fields of crime scene investigation, cell phone, and forensic data recovery.
Okay, counsel for defense, any objection?
Yes, Your Honor, if I may perform a brief voir dire of Detective Markowitz.
Brief, please.
Detective Markowitz, you don't claim to have any education in crime scene investigation, do you?
Not in specific crime scene investigation, but I do specialize in data reconstruction, and all of the evidence in this case required that specialty.
But you also have no credentials specifically in crime scene investigation.
In investigation, no, but I have over 7 years of experience.
Very well. Under Rule 702, I object to Detective Markowitz being admitted as a crime scene investigator, as she has no credentials which qualify him as such.
And counsel response?
Yes, Your Honor. Under Rule 702, an expert witness may be entered if they have skill, experience, training, or education. In this case, Detective Markowitz has 7 years of experience as a homicide detective with the Denver Police Department, and therefore has enough experience to testify as an expert witness in this field.
All right, thank you. Any brief reply?
I stand by my objection.
Thank you. Having heard the arguments of both counsel, the court will allow the witness to testify as an expert witness. The jury will be, of course, be able to give to that person whatever weight they wish to give to it, given the voir dire and objection. But he'll be so recognized. Ready to proceed, counsel?
Yes, Your Honor. Detective Markowitz, you said you came to an opinion. What was that opinion?
Yes, it is my expert opinion in my case, after reviewing all of the evidence, that Ms. Becker went to Mackenzie Brackman's house on March 6th of 2020 and killed Mr. Brackman.
Now let's talk about how you came to that opinion. How were you first involved in this case?
Well, I first became involved in this case when a passing motorist reported a passed out body on the porch of 444 South Flower Street, which I thought was slightly odd considering when I arrived at the scene, the body was just inside the house.
Did you recognize the victim?
Not at first, but once I saw the victim's ID, I did recognize the victim as a criminal defense lawyer, Mackenzie Brackman.
And did you take any photos of the body when you saw it?
Yes, I did.
And would you recognize these photos if they were shown to you?
Yes.
Please turn your attention to Exhibit 2. Is this a fair and accurate depiction of the body when you saw it?
Yes, it is.
Your Honor, I now move to enter Exhibit 2.
Any objection?
No objection, Your Honor.
This be so admitted. Thank you.
Now, Detective Markowitz, from the position of this body, what could you tell?
Well, from this picture and my investigation at the crime scene, I could tell that Mr. Brackman was stabbed within the interior of the home and then tried to flee the scene via the front door. However, he was unable to, as we can see his hand reaching out, attempting to flee, but he collapsed face down in a pool of blood before he could do so.
Did you observe the weapon of attack?
Yes, it was a large kitchen knife.
Now, after reviewing this, where did you go?
Next, I walked around the exterior of the home.
What did you notice there?
I noticed 3 different Ring doorbell cameras.
And did you review the footage from these cameras?
Yes, upon downloading the contents of Mr. Brackman's phone, I witnessed 4 different videos of the perpetrator entering and exiting the victim's home on the day of March 6th of 2020.
Now, please turn your attention to Exhibit 12. Can you identify this video?
Yes, this video shows the perpetrator waltzing, as I like to say, into the house and then slamming the door behind him, causing some sort of commotion. And yeah.
And is this a fair and accurate depiction of the video you reviewed from the Ring doorbell footage?
Absolutely.
Your Honor, I now move to enter Exhibit 12.
Any objection?
No objection, Your Honor.
Be so admitted. Thank you.
And so after seeing the Ring doorbells, where did you go?
Next, I entered through this same door of the home and went into the living room of the house.
What did you see there?
Well, within this area of the house, I saw a scene that looked like it was in slight disarray. There was a toppled over chair, a broken plate on the floor, and in the nearby kitchen, there was a missing slot in the knife block and an open knife drawer.
Did you see any blood at the scene?
I did. I saw droplets of blood leaving from the living room / kitchen area to the front door of the victim's body, as well as blood spatter near and around the victim's body on the wall and ceiling.
What did this show you?
Well, this showed me that Mr. Brackman was somehow alerted of the intruder's presence, armed himself with a large knife. There was some sort of scuffle between the intruder and Mr. Brackman. However, the intruder got a hold of the knife, stabbed Mr. Brackman. Mr. Brackman tried to flee the scene, and again.
Well, let him finish let me hear the question again, please.
What did this show you?
Okay.
Well,
Counsel,
this showed me that Mr. Brackman was.
Hold on. Counsel, you had an objection. Is that right?
Yes, I was objecting that this testimony goes more into crime scene reconstruction, which Detective Jordan Markowitz is not admitted under, and so it's outside the realm of his expertise.
Okay, response.
Yes, Your Honor. He is testifying about what he observed in his crime scene investigation, seeing the videos, seeing the blood splatters, seeing the condition of the house. And so this is going to his expertise in crime scene investigation. And through this investigation, he is able to make an expert opinion on what happened inside the house. Okay,
reply?
I would stand by my objection.
All right, the objection's overruled. The witness will be allowed to answer.
Now, Detective Markowitz, what did this show you?
So again, this showed me that Mr. Brackman was somehow alerted of the intruder's presence and armed himself with a large knife. The intruder and Mr. Brackman, they got in some sort of scuffle. The intruder got a hold of this knife and stabbed Mr. Brackman in the back. And then Mr. Brackman tried to flee the scene. This was evident by the drops of blood that were leading from the kitchen area to the front door. And then Mr. Brackman collapsed face down in a pool of blood before he was able to leave.
Now, after reviewing the crime scene, what did you do?
Well, next I turned to the evidence. I looked at Mr. Brackman's phone, specifically the numerous texts and emails relating to Mr. Brackman's coaching work for the Colorado High School mock trial team.
What did you find there?
Well, here I found various names and numbers of different students that Mr. Brackman coached, and I contacted the first student on the list by the name of Alex Cifuentes.
What did you learn from Mr. Cifuentes?
Well, from Mr. Cifuentes, another student apparently sent him text messages that provided some sort of threat towards Mr. Brackman and his home.
Did you ever learn who the student was?
Yes, I learned that this student was a Miss Avery Becker, the defendant in this trial.
And did you ever receive screenshots of these text messages?
Yes, I told Mr. Cifuentes to send me the screenshots after our interview.
Please turn your attention to Exhibit 14. Is this a fair and accurate depiction of the screenshots you received?
Yes.
Your Honor, I now move to enter Exhibit 14.
Any objection?
Yes, Your Honor.
Go ahead.
This is a copy of a screenshot Detective Markowitz received and so is a duplicate. And under Rule 1003, duplicates are only admissible if the authenticity of the original is not under question, which there are some serious questions as to the authenticity of the original text messages.
Okay, response?
Yes, Your Honor. Under Rule 1003, the admissibility of a duplicate is allowed in court if the authenticity question has not been raised. In this case, no question to authenticity has been raised with these text messages. Detective Markowitz reviewed them in his investigation, relied on them, and therefore they are authentic and authentic messages of what he received from Mr. Cifuentes.
Okay, brief reply. Any reply?
I stand by my objection, Your Honor.
All right. The exhibit will be admitted. Once again, the jury can give what weight it wants to it, given the objection, but it'll be admitted.
Now, Detective Markowitz, what stood out to you from these text messages?
Well, from this exhibit, there are two specific gray bubbles that stood out to me. The first one is right here on the screen. Well, if he's still upset about his car, then he's gonna be really upset when he sees what I do to his house. And then right below that, we can see, I'm gonna wait until he's at work, then break in and trash it. And that is coming from Avery Becker, the defendant in this trial.
And so after reviewing these, what did you do?
Well, next, I obtained a court order for Ms. Becker's call detail records, specifically through her service provider.
What are call detail records?
Well, I'm glad you asked that question. Call detail records can determine the time and very location of an individual's phone based off when they place a text message or phone call. This is then relayed to a cell tower, specifically the antenna. You can then determine the exact cell tower and antenna, and then from this, you can determine an individual's phone location, the location of the phone to be precise.
And did you review a map of these CDR records that were Avery Becker's?
I did.
Please turn your attention to Exhibit 15. Is this that map?
It absolutely is.
Is this a fair and accurate depiction of that map?
Yes.
Your Honor, I now move to enter Exhibit 15.
Any objection?
No objection, Your Honor.
Be admitted. Thank you.
Now, Detective Markowitz, can you please circle where Ms. Becker's home is?
Absolutely. I believe Ms. Becker's home is right here in the top right corner.
And can you please circle where Mr. Brackman's home is?
Yes, Mr. Brackman's home is in the bottom left corner of the exhibit.
And based on your review of the call detail records in red, could you determine a possible route that Ms. Becker took on March 6th?
Absolutely. One of the routes, in fact, the most likely route that I believe Ms. Becker took on March 6, 2020 is precisely as followed. Along here, into Ms. Becker's home. And this is all based off of various text messages and calls that Ms. Becker placed directly before the murder of Mr. Brackman.
Your Honor, I now move to enter Exhibit 15, the demonstrative version, as Exhibit 15A evidence.
Any objection, counsel?
No objection, Your Honor.
Be admitted.
Now, Detective Markowitz, after reviewing all of this evidence and based on your experience, what did you finally conclude on what happened around and during March 6th?
Well, based on the call detail records, the investigation of the crime scene, and the investigation of the victim's body, it is absolutely clear that Ms. Becker went to Mackenzie Brackman's house on March 6, 2020, and somehow got a hold of Mr. Brackman's knife in a scuffle, stabbed Mr. Brackman in the back, and killed Mr. Brackman.
No further questions, Your Honor.
All right, thank you. Cross-examination.
Yes, Your Honor. May I proceed?
Please.
Detective Markowitz, you mentioned blood spatter that you noticed at the crime scene earlier?
Yes, absolutely. The blood spatter was on the surrounding wall and ceiling of the victim's body.
Photos taken of this blood spatter were corrupted.
Sadly, yes, a faulty system software at the DPD somehow lost the photos, and I'd have to attribute that to our funding.
And yet you still describe that the blood made cast-off marks in your witness testimony.
Yes, I do. I specifically mentioned I'm not an expert in cast-off marks. However, I have numerous years of experience at crime scenes and could say that those were definitely cast-off marks, as I have recognized before.
But you will ask us to rely on your untrained opinion, more or less, since we have no physical evidence of the blood.
Well, again, from my 13 years of experience as a DPD and my numerous investigations, yes, that's what I would ask you to base your opinion on, as my expertise.
Let's cover your theory of what happens inside the house. You say that the victim discovered an intruder breaking in.
Yes.
And that the victim then confronted the intruder with a knife.
Yes.
And that somehow they lost this knife in a struggle.
Yes, that is what the crime scene showed me.
And the victim was then stabbed by their own knife.
Yes.
And you came to this conclusion after only your first scan of the home.
Scan of the home, as well as the videos, specifically in the videos, as we showed in Exhibit 1. The intruder just walks into the house aggressively and slams the door, obviously making commotion, not entering silently. Mr. Brackman was obviously alerted of the intruder's presence through this.
And so you came to this theory that there was a struggle using only some videos of someone entering the house.
Some videos, yes, as well as the scene was in disarray. There were scuff marks on the floor, as I forgot to mention, a broken plate, and a toppled over chair. All of this showed me that there did seem to be some sort of scuffle. There was not just a murder. There was a confrontation between the two individuals. I also stated in my statement that I believe Mr. Brackman was somehow alerted from a Ring doorbell notification. That is another reason he could have been alerted, along with the video of him opening the door.
But you also mentioned in your witness statement that you could not tell if the disarray was just the normal state of the house or due to the break-in.
Upon walking in, yes, that was my first thought.
So when you accessed Mr. Brackman's Ring account, you only downloaded camera footage.
All of the camera footage, yes. I downloaded everything that I found to be pertinent to this case. Anything else I did not include in my witness statement.
Yes, in fact, what you did not get were his notification settings.
I actually never testified about getting the notification settings in my witness statement. Would you still like me to answer that question?
No, that's quite all right. So, Detective, you began your lead on Avery after talking with Alex Cifuentes.
Yes, after receiving screenshots of a conversation between Miss Avery and Alex Cifuentes.
Yes, you suspected Avery because of those screenshots shown to you.
Yes.
But when you met Alex, he didn't bring his phone, which had those texts on it.
No, he forgot his phone at home.
Wasn't the entire meeting between you and Alex to discuss the death of Mr. Brackman?
Yes, and we certainly did.
And you never saw these texts yourself?
No, but my investigation through the CDRs confirmed the validity of these text messages.
But since you never saw these texts yourself, you agree they could be staged or altered.
Well, I'm gonna have to disagree with the pretense of that question, but I guess there could be a small possibility that they could have been altered. But again, my investigation told me that they weren't.
Was that a yes?
Again, I said I disagree with the pretense of that question, but but there could be a small possibility they were altered in some way. But I came to the conclusion that they were not.
Very well. As a CDR expert, you know that if a phone is near a busy tower, it can connect to one which is less busy and maybe further away.
Yes.
Then it is possible that rather than moving towards Brackman's home, as you suggested, Avery's phone was simply connecting to the least busy tower.
No, that is not the case. I know the exact cell phone tower, in fact, the exact cell phone tower antenna that Miss Becker's phone contacted on the day of the murder. That is what CDRs show. I merely just laid out the foundation for that statement, but that is true. Phones can connect to different towers depending on the demographic and how many people are in an area.
I'm sorry, could you answer my question?
Could you re-ask your question, please?
Yes, rather than moving, could Avery's phone have simply connected to the least busy cell phone tower, and that's what your CDRs picked up on?
No. In my statement, I specifically say that I know for a fact which tower Miss Becker's phone connect to. Therefore, I can pinpoint her location from her house. I believe that would be cell phone tower 1227-3. And then her phone then travels to the next cell phone tower, specifically that antenna, and then the tower again towards Mr. Brackman's house. So unless it was all one big coincidence, which I have never seen in my 7 years of investigation, and Miss Becker was somehow at the mall, I guess that could be the case, but I never see coincidences as a homicide detective, especially pertaining to murder.
But you still admit that could be a coincidence, so it is a possibility.
Possibility, yes. Coincidences simply do not happen in my experience.
And detective, cell towers don't show the exact location of a cell phone, but rather the general area of where a cell phone might be.
The area of the antenna. Cell phone towers cover a very large, a very broad area of land.
Yes, and you never mentioned how large this area that the cell towers cover is in your witness testimony.
Well, according to Exhibit 15 and 16, you can see the amount of area pertaining to the map that a specific antenna covers.
But we do not know an exact area.
An exact area? No, I could estimate for you if you would like. However, I do not testify to that in my witness statement.
And Avery's phone could be anywhere in that large unspecified area.
In the area of the specific antenna. It's not the entire area of the cell phone tower. There are multiple antennas that cover a 120-degree arc. So I know Miss Becker's phone was in that area of the specific antenna.
And you also have no evidence that Avery's phone was even with her at the time.
I strongly disagree with the pretense of that question again. From the text messages that Mr. Cifuentes sent me, I could confirm that Avery Becker had planned to go to Mr. Brackman's house, therefore she had her phone with her. So again, if it was one big coincidence, I guess Miss Becker could not have had her phone, but again, I don't rely on coincidences when I look at cold hard evidence.
That was a yes.
Again, yes, I'm sure it could have happened in that specific circumstance.
All right, detective. You believe that good detective work requires you to follow up on all leads?
Yes, absolutely.
And at the beginning of the case, you had 2 leads.
I believe that would be a disgruntled ex-client and Miss Becker or some sort of, sorry, not Miss Becker, one of the individuals involved in mock trial work with Mr. Brackman, I believe I stated.
Yes, you also thought it could be a random burglary.
Absolutely.
But you didn't pursue any of the, either of the 2 leads, you didn't pursue the random burglary lead.
Well, I never discussed pursuing any other lead in my statement because I did not feel it was important to include it. I only included the evidence and the suspect that I felt was most pertinent to this case.
And you didn't pursue, or you at least don't discuss pursuing the disgruntled ex-client lead.
I do not discuss pursuing the disgruntled ex-client, no.
In fact, you didn't pursue any leads other than my client Avery.
Again, I do not specifically discuss that in my witness statement. Would you still like me to answer that question?
No, that's fine. Thank you, Your Honor. I have no further questions for this witness at this time.
Okay, thank you. Any redirect?
Yes, Your Honor. Now, Detective Markowitz, you were asked about the call detail records. Do they pinpoint Ms. Becker's exact location?
Her exact location, no, but her phone locations, yes.
And did that show where she was on March 6th?
Yes, through the text messages, as I stated from Alex Cifuentes, it did directly connect her to her phone, which allowed me to determine her location on March 6, 2020.
And where was she on March 6th?
Well, on March 6, 2020, she was at her house at 12:47 p.m., traveled to Mr. Brackman's house between 12:47 and 1:05 p.m., and was at Mr. Brackman's house between 1:05 p.m. and 1:17 p.m. on March 6, 2020.
No further questions, Your Honor.
All right, any recross this first witness?
No, Your Honor.
Okay, thank you. And is the prosecution ready to call their next witness?
Yes, Your Honor.
Okay, please.
The prosecution calls Alex Cifuentes. May I proceed?
Yeah, let me see him for him just a minute. You understand the oath that I gave to the prior witness?
Yes, Your Honor.
And you understand you would be under that same oath, is that correct?
Yes, Your Honor.
Okay, thank you. Proceed.
Mr. Cifuentes, please state your name and spell your last for the court.
My name is Alex Cifuentes, Sifuentes.
And do you currently attend high school?
Yes, I'm currently a senior at Colorado High School.
And do you know the defendant, Avery Becker?
Yes, Avery was on my mock trial team. Avery invited me to join mock trial when I was a freshman.
And did you know Mackenzie Brackman?
Yes, Coach B, he was my mock trial coach ever since I was a freshman.
And from your personal observations, what was the relationship between Avery Becker and Coach Brackman like?
It was always strenuous. It was like Coach Brackman was Batman and Avery was the Joker. It was never a good mix.
And in these certain situations, how would Miss Becker react?
Avery would never react well. She always took the criticism, not as Mr. Brackman in a coaching position, but more as if she was over him.
Objection, Your Honor. Lack of personal knowledge. This witness cannot testify to how Avery personally took it. He can testify to how she seemed to take it.
All right, and response?
Your Honor, this witness was in mock trial with Avery and Coach Brackman. He's testifying on what he observed between the relationship between the two. Therefore, it is personal observations, and he's not speculating at all.
And any reply?
If that's the case, I would just ask that the witness clarify that they are not, in fact, testifying to Avery Becker's feelings on the matter or what was going on inside her mind, and keep it strictly within the realm of personal observation.
All right, counsel, can you rephrase the question?
Yes, Your Honor. So from your personal observations, how did you see Miss Becker reacting in these certain situations?
It was blatant at practice in front of all of us that Avery would never take Coach's criticism well.
I'm going to ask you a couple questions concerning the regional tournament last year. How did the defendant do at the tournament?
Avery did well, skated by just on the fly, and would come up with things on short notice, whereas we would prepare a long time for our examinations.
And after the regional tournament, were there any further disagreements between Coach Brackman and the defendant that you witnessed?
Yes, after practice, after the regional tournament, Coach Brackman gave Avery a reality check and said that if what she was doing would be considered malpractice in the real world.
And how did the defendant react to that?
Avery became infuriated, took a Sharpie on her way out the door, and wrote Worst Attorney Award all over Coach's 1986 Porsche 911, which, I mean, that car could be in Fast and Furious. it wouldn't be a match to O'Connor's skyline, but it would be pretty close.
Mr. Cifuentes, how do you know what kind of marker that she used?
The Sharpies are kept on an easel of paper where we write our trial ideas, and the Sharpies and dry erase markers don't even look the same.
And do you know if the defendant had a consequence to this incident?
Yes, Avery was kicked off the team shortly thereafter.
Were you contacted by Miss Becker after she was kicked off the team?
Yes, Avery texted me asking if I would talk to Coach Brackman on her behalf.
And did you talk to Coach on her behalf as you were asked to?
Yes.
Your Honor, permission to share Exhibit 14. It has been previously admitted.
Yes.
Mr. Cifuentes, after you said you doubt anyone could change the coach's mind, what did the defendant say?
Avery said, and I quote, "Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house."
Did you respond to that?
Yes, I responded with, "What are you going to do to his house?"
And what was the next thing that Miss Becker said?
Avery said, "I'm going to wait until he's at work and then break in and trash it."
Thank you. That'll be all for the screen sharing. So after Coach Brackman was murdered, were you contacted by the police?
Yes, Detective Markowitz reached out to me asking if I had any information.
And did you meet with the police in person?
Yes, after I was on the phone with Detective Markowitz, he asked me to come in for a full interview. I mean, that's like CSI.
And did you bring your phone with you that day?
No, I left it at home on the charger by accident in a rush to get to the police station.
So did Detective Markowitz ever see these text messages?
Yes, he did. I emailed copies of what I received from Avery to Detective Markowitz.
Are the copies of the text in Exhibit 14 what you sent Detective Markowitz?
Yes, they are.
Mr. Cifuentes, where were you on Thursday, March 5th?
Well, Thursday I was at the Fry Shack with some of the other mockers. We like to go there from time to time. And we saw Avery there.
Thank you, Mr. Cifuentes. And did you see if Miss Becker had her phone with her?
Yes, Avery did have her phone that night.
And did you ever come in contact with her phone?
Yes, Avery showed me this new game on her phone and let me give it a try.
Did you end up taking the defendant's phone?
No, I didn't.
And did you alter her phone in any way?
No, I mean, that's some James Bond level stuff. That's not really.
And Mr. Cifuentes, do you know of a person named Blair Rollins?
I know of Blair Rollins. I went to school with him. That's about it.
So were you friends with him?
No.
And did you give the defendant's phone to Blair Rollins?
Why? In the first place, I barely know Blair. So why would I give Blair someone else's phone when I don't even know Blair that well?
Thank you, Mr. Cifuentes. No further questions.
All right, thank you. Cross-examination, Ms. Taylor.
Yes, Your Honor. Good morning, Mr. Cifuentes. My name is Morgan Taylor, and I'm representing Avery Becker. Mr. Brackman was your mock trial coach.
Yes, Coach B coached us ever since I was a freshman.
You looked up to him?
Yes.
You really respected him as a lawyer?
I did respect him, yes.
And you and Avery Becker were on mock trial together?
Yes, we were on the same team.
And she was the original reason you joined the team in your freshman year?
Avery invited me freshman year, so I'd say yes.
And you and Avery did mock trial together for 3 full years, correct?
Yes.
Mr. Cifuentes, you spend a lot of time on mock trial.
Yeah, I spend a lot of time preparing my examinations. I mean, I took this super seriously.
And Avery didn't.
Avery skated by. She would come up with things on the fly, which, I mean, she won awards, and an award for Avery is an award for the team.
Thank you, Mr. Cifuentes. No need to elaborate. You did well at mock trial.
I like to think I did.
But Avery did better than you.
I mean, when you're in mock trial, one of the scoring panelists can give you a higher score because they maybe like your closing argument, and that's how you might be able to get the award. So Avery did score better than me at the tournament.
You might have worked harder, but Avery still scored higher at tournaments.
Yes, Avery did score higher because some of the scoring panelists might have liked her arguments better.
Mr. Cifuentes, again, no need to elaborate. You don't think that Avery was deserving?
I personally thought that I worked harder, but like I said, Avery's awards are awards for the whole team.
Mr. Cifuentes, please answer the question. You don't think that Avery was deserving?
Well, I think we're having a bit of a miscommunication right here. That seems like an open question, and I did see Avery winning awards, which, like I said, an award for Avery is an award for the team.
Okay, Mr. Cifuentes, if you'd like me to clarify the question, you do not think that Avery was deserving of the specific awards that she got at tournaments?
I personally thought that I might have deserved a bit more, but I mean, I'm not the scoring panelist.
Thank you, Mr. Cifuentes. In spite of this odd relationship, Avery texted you about getting back on the team.
Yes, after the Porsche incident, Avery did reach out to me and asked me to talk to Coach Brackman.
Mr. Cifuentes, that was already established in your direct, so no need to elaborate on these answers. For almost all of my questions, a yes or no will suffice.
Objection, Your Honor. Counsel is not forming her sentences in the form of a question. I ask that she not talk to my witness directly.
Counsel, reply.
Your Honor, that's a fair objection. I'll fix that for the rest of my questions. Thank you, opposing counsel.
All right, thank you. Proceed.
The number labeled as Avery confessed to planning on trashing Mr. Brackman's house.
Yes, Avery said that she was going to break in while Coach was at work, which, I mean, I guess Coach wasn't at work because that's when she killed him.
She confessed this to you, and yet you didn't see a reason to go to the police?
Well, at the time, I mean, I didn't really peg Avery as someone to break into our coach's house, much less kill him. So I didn't take it as seriously as, like, now that I'm looking back, I probably should have. And that's going to change for the rest of my life.
Mr. Cifuentes, you have already testified to seeing Avery go out and write on the coach's car, and yet you didn't even see it necessary to shoot him a quick text?
Avery was at practice and was storming out of practice in a fit of rage, and that's when she wrote on Coach's car.
You brought screenshots of these texts to the police.
I emailed them to Detective Markowitz after our interview.
Thank you. And these texts have no dated timestamp.
They do not appear to have a timestamp or a date stamp, no.
And the phone they were received on has been conveniently traded in?
And not conveniently. I mean, my phone wouldn't hold a charge anymore, so I really need to get a new phone that would actually hold a charge.
So as a matter of convenience, you got a new phone?
Yes, as a matter of convenience to me, so that way my phone wouldn't die multiple times throughout the day. That's why I accidentally left it at home, because I was trying to charge it in order to have it when I need to go to the police station.
Mr. Cifuentes, there is no record left of these text messages except for the printouts.
Yes, those printouts were exactly what was on my phone and exactly what I emailed Detective Markowitz.
And there's no record left of them.
Like I said, I was able to trade in my phone because the evidence had been given to Detective Markowitz.
Yes or no question. All right. Thank you, Mr. Cifuentes. I have no further questions for this witness at this time, Your Honor.
All right, thank you. Any brief redirect?
No, Your Honor.
Okay, thank you very much. And the prosecution able to call their next witness?
Yes, the prosecution calls Mr. Kyle Cusack.
Okay, Mr. Cusack, you understand the oath that was given to the first witness and the second witness. You understand that oath, is that right?
Yes, Your Honor.
Okay, and you're under those same rules as the oath provides for the other two witnesses, yes?
Yes, Your Honor, understood.
Okay, thank you. Proceed.
Mr. Cusack, could you please state your name and spell your last for the court?
Good morning. My name is Kyle Cusack, K-U-Z-A-K.
What do you do for a living?
Well, I'm a civilian that's contracted out to different police departments for the specialty of crime scene reconstruction.
Crime scene reconstruction. Could you describe for the jury what that is?
Well, crime scene reconstruction is taking the pieces given to you by the investigation by the detective and putting those pieces together to see what really happened at the scene of the crime.
Do you have any certification in this field?
Yes. Now, 19 years ago, I was board certified by the Colorado Bureau of Investigation. They oversee the CSR certification process.
During those 19 years, what sorts of cases have you worked on?
Oh, I've worked on all of them. We have car accidents, armed robberies, burglaries, break-ins, homicides, you name it.
Now, today, were you asked to reach some expert opinions for today's case?
I was, yeah.
Did you reach any?
I did, yes.
Your Honor, at this time, I offer Mr. Kyle Cusack as an expert in the field of crime scene investigation and reconstruction.
Any objection, counsel?
Yes, Your Honor, a brief voir dire.
Brief, thank you.
You have 19 years of experience in crime scene reconstruction,
Yes, ma'am.
yet none in crime scene investigation.
Crime scene investigation falls under my expertise of crime scene reconstruction.
And you have no education in either of these fields.
Well, to become board certified, when you go in front of that big board and you start answering their questions, you better have some sort of education.
Yes, but you have not stated that you have had any education, correct?
The certification implies my education.
Okay. Your Honor, I object to Kyle Cusack being admitted as an expert in crime scene investigation because he only has experience in crime scene reconstruction and he has no education in any of the fields.
All right, thank you. Any response to that objection?
Yes, Your Honor. This witness meets the requirements under Rule 702 for an expert witness. I've laid proper foundation that Mr. Cusack has the knowledge, skill, experience, education, or training in the field of crime scene investigation and reconstruction. Now, Mr. Cusack just testified that he has training from the Colorado Bureau of Investigation, as well as has worked in the field for 19 years. Now, counsel is arguing that the investigation aspect of crime scene reconstruction does not necessarily fall under crime scene reconstruction. Now, I'd like for the court to know that crime scene reconstruction is a specialization of investigation itself. Now, in being certified in reconstruction, he has also had training in investigation.
All right, any brief reply?
Your Honor, nowhere does the witness state that he has had any training or education or experience in crime scene investigation. Crime scene reconstruction, he does. I have no objection to crime scene reconstruction. Crime scene investigation, however, he has no experience, training, or education in.
All right, very well. The court will allow him to testify as an expert in both. The jury certainly will have the opportunity to give whatever weight they feel is appropriate based upon the objection made. Proceed.
Mr. Cusack, you mentioned some opinions. What were they?
Well, first, the perpetrator, Ms. Becker, wanted or tried to break into the house in the front, and she couldn't get in, so she moved around to the back. And by the time that she left, Mr. Brackman was dead.
Now, let's talk about your involvement in the case. How did you become involved?
Well, I received a phone call from Detective Markowitz. You heard from him earlier, and he said that they have a messy crime scene on their hands and that they needed me to come out to the scene immediately.
Now, once on the scene, how did you go about collecting evidence?
Well, I worked closely with the investigators. I took a couple pictures of my own, but really, I wanted to get an overview. I wanted to start collecting pieces to ultimately form a puzzle.
Now, this puzzle, what methodology do you use when forming these pieces together?
Well, throughout my 19 years, I've developed a tried and true methodology. It involves 5 steps.
Could you walk the jury briefly through those 5 steps?
Absolutely. So my first step I call recognition and documentation. This is like receiving the puzzle pieces from the investigation. Now, steps 2 and steps 3 are my collection and my evaluation of the evidence. I start to look at the puzzles. I look at the corner pieces, look at the side pieces, start to fill in some of the easier pieces by corroborating or refuting evidence. Step 4 is where we really get into the difficult puzzle pieces, maybe the sky, that's all the same color. It is more difficult, but through my peer review, my lab submissions and analysis, I'm able to finally form step number 5, which is when the puzzle is put together. That's when we see what really happened at the scene of the crime.
Thank you, Mr. Cusack. Now, with this methodology in mind, let's walk through what occurred on the day of March 6th. How did the perpetrator enter the residence?
Well, like I said, the perpetrator first tried the front door, but couldn't get in. And so in that video that you saw, she got in through the back.
Now, once the perpetrator entered, what do you believe to have happened?
Well, obviously, I was at the scene of the crime, and there are some pictures that I took. There's marks on the ground. They're called scuff marks in crime scene reconstruction. They're made by shoes, and they're made when some sort of struggle, altercation, whatever you want to call it, happens. And also there's a broken plate, and there was a knocked over chair.
Now, what did these three seemingly unrelated things tell you about what occurred?
Well, it was obvious that Mr. Brackman was ready for the intruder with a knife. And once the intruder entered, some sort of scuffle between the two ensued, and Ms. Becker responded with force.
Got her permission to share Exhibit 18.
Please.
Mr. Cusack, could you see the exhibit in front of you?
Unfortunately, I cannot. I do have a copy in front of me in a paper version.
All right.
Oh, now I can see it.
Perfect. Could you describe what this is for the jury?
Well, these, in front of me now. These are the scuff marks created by the shoes I was just talking about.
And is this a fair and accurate depiction of what you viewed at the scene of the crime?
Yes, this is one of the few pictures that I actually took myself.
Your Honor, the prosecution moves to enter Exhibit 18.
Any objection?
Yes, Your Honor. Under Rule 901, the witness in question has to provide sufficient evidence to support that the photo in this case is what he claims it is. Specifically, he says that these are scuff marks, and he claimed earlier that they had to be made during the struggle. He has no evidence to the fact that they absolutely had to be made during the struggle, so this violates Rule 901.
Your Honor, under Rule under Rule 901B1, testimony of a witness with knowledge. This is an expert witness, and he's testifying directly to his knowledge of what occurred in his expertise of crime scene reconstruction. Now, with that being said, this witness has the knowledge to authenticate this image in front of us right now. Therefore, this would simply go to the weight, not the admissibility.
All right, the real issue right now is the admissibility of the exhibit, and it'll be admitted. Proceed.
Mr. Cusack, what exactly did the scuff marks tell you?
Well, it showed me that just inside the back door, right after the exhibit that you saw, the video, Ms. Becker encountered Mr. Brackman, and they had some sort of fight, altercation, scuffle.
Now, as this altercation progressed, what happened?
I believe that the altercation moved from the back door to Mr. Brackman's counter, Mr. Brackman's kitchen counter. And during that time, he was stabbed in the back.
And let's look at the knife he was stabbed with. Your Honor, permission to share what has been previously marked as Exhibit 5.
Yes.
Well, what is this?
Well, this is the knife that I saw at the crime scene.
And is this a fair and accurate representation of what you viewed while you were there?
Yeah.
Your Honor, at this time, the prosecution moves to enter Exhibit 5 into evidence.
Any objection, counsel?
No objection, Your Honor.
I'll be admitted. Thank you.
Looking at the knife as well as the stab wound, how exactly was Mr. Brackman stabbed?
Well, counsel, if you want me to get all scientific about it, Mr. Brackman was stabbed just inferior to his scapula, with the knife piercing the inferior tip of his scapula and significantly plugging the aorta. Now, when the aortic arch was unplugged with the removal of the knife, he died out from bleeding. What that means in less fancy terms is Mr. Brackman was stabbed in the back, and once the knife was removed, he bled out.
Thank you. Let's move on. Do you know Professor Blake Van Owen?
I know of Professor Blake Van Owen. Miss, I like to refer to her as.
And how do you know Miss Van Owen?
I've seen her at some conferences. I've unfortunately had the displeasure of working or having her sit across the aisle.
Do you know of Professor Van Owen's CSR qualifications?
I know she claims to have CSR qualifications, if that's what you're asking, counsel.
Do you know how, from your own personal observations, being involved in cases with Professor Van Owen, do you know how she goes about conducting her CSR?
Well, first, I'd like to explain my CSR qualifications. What makes me different from just a family putting together a puzzle at a retirement home or something? I'm a puzzle master because I don't have that picture of the puzzle on the back of the box. I have to put the pieces together without seeing it. Now, Professor Van Owen, she seems to have pulled up a different picture, and she tries to fit the puzzle pieces into a puzzle that's just not the same picture. It doesn't work.
Now, in relation to Professor excuse me, do you know of Professor Van Owen's theory for today's case?
Yes, I do.
And could you briefly describe it?
Well, Miss Van Owen's theory is that Mr. Brackman was doing his work, sitting at his table. The intruder walked in through the back door, and he continued doing his work, and then he was stabbed in the back. That's Miss Van Owen's theory.
Now, why is this not the case?
Well, there's all sorts of things. First, Mr. Brackman had Ring doorbell cameras. Now, these cameras, when they detect movement, will alert the user on their phone. Mr. Brackman, sitting at his table, would have seen that there was some sort of notification on his phone. When the intruder moved to the back, he would have known somebody was trying to break in. Now, that's only one piece that Miss Van Owen failed to recognize. Miss Van Owen also failed to recognize that the door was open. It makes sound. I think you heard it. Additionally, it was a wood floor. There's sound that wood makes when somebody walks on it. And Professor Van Owen neglected to mention the broken plate or the scuff marks.
Now, you mentioned the door being opened. Now, in accordance with Professor Van Owen's theory that he was at his table, about how far away is the table from the door?
Well, I was at the scene of the crime. It's not a huge house. It's like right there.
Thank you, Mr. Cusack. No further questions, Your Honor.
All right, thank you. Cross-examination.
Yes, Your Honor. You decided that you are more qualified as a crime scene reconstructor. I'm sorry, let me rephrase. You decided that Professor Van Owen's theory is inferior after already having the bias that you are a superior crime scene reconstructor?
No, ma'am, there was no bias in this case.
But you do agree that you decided that her theory is inferior after already deciding that she is not a good CSR.
No, I didn't decide it. I think everybody in Colorado who works in CSR knows that. And if you're asking that there was any inherent bias, no, I just looked at the evidence.
Okay, great. Thank you. And your theory requires the Ring doorbell alerts to have been heard.
That could have happened. I believe that Mr. Brackman still could have been alerted if he did not receive those notifications.
Great, thank you. And it is possible that he had not heard the notifications because he did not have his phone on him or they were turned off.
That's a likely possibility, but he would have heard somebody trying to open the front door.
I don't claim to check either of these possibilities.
Well, I'm presented with the puzzle pieces and I put those pieces together. I don't necessarily find the pieces.
And, okay, photos you used in your conclusion have since been corrupted.
Yes, ma'am, they have.
So you used corrupted evidence in your final investigation?
No, ma'am, my final investigation was complete before the photos were corrupted. I was going through peer review when they were corrupted, so everything was finished. I was in step number 4, moving to step number 5.
And there is a possibility that the intruder brought the knife.
Is there a possibility? Yes, after looking at the evidence, that piece doesn't quite fit this puzzle.
But there is a possibility.
Absolutely. There's a possibility that Mr. Brackman did a bunch of jumping jacks before he ran to the knife, but I don't think it's likely.
And you did have to speculate most of your conclusion.
Ma'am, the nature of crime scene reconstruction, it's speculative.
Okay, great. So you made educated guesses.
educated guesses based on my analytical findings and evidentiary relationships.
But you are not educated in the
Time is up.
instruction.
Somehow we just got somebody new in here.
Time is up.
Oh, okay. Thank you. Are there any further witnesses for the prosecution?
No, Your Honor. At this time, the prosecution rests.
Okay, very well. Everybody take a deep breath and let me make sure that the scorers in this case understand that they are to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition. If anybody who is on the scoring panel has a problem with that, so indicate. Otherwise, we'll assume that your answer is you do. All right, thank you very much. Any witnesses to be called by the defense?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
All right.
Good morning. May you please state your name for the record?
Excuse me one second. You heard the oath that I provided to the other witnesses, is that right?
Yes, Your Honor.
Okay, and you understand the same oath would apply to you, is that right?
Yes, Your Honor.
Okay, thank you very much. Proceed.
May you please state your name for the record?
I'm Professor Blake Van Owen.
And what is your current occupation?
I'm a former police officer with the Aurora Police Department, and currently I am a private investigator and a professor at CU Denver and have been a professor for 5 years.
How does your former police work influence you as a PI?
Being a former police officer, I know the system inside and out, and I use what I learned as a police officer in my work as a PI every single day.
And what are your qualifications for being in this trial?
I've been accepted as a defense expert in the U.S. District Courts in 4 states. I've been accepted as an expert in crime scene reconstruction, cell tower analysis, and general police practices over 5 times each. I teach a course in police procedures, and I have my master's degree in criminal justice from Ashford University.
Your Honor, I move to qualify Professor Blake Van Owen as an expert in crime scene reconstruction, cell tower analysis, and police practices.
All right, any objection?
Yes, Your Honor. May I request a brief word here?
Brief, yes.
Professor Van Owen, you claim to be...
Proceed.
My apologies, Your Honor.
No problem.
Professor Van Owen, you claim to be an expert in police practices, isn't that right?
Yes.
But you were only a part of the police force for 9 months, isn't that right?
I guess so. An active member, however.
And that was in 2005.
Yes, that I was an active member.
So your purported expertise in regards to police practices is based on a 9-month experience from over 15 years ago.
Not solely based on that. My active experience was 9 months. However, I continue to study those practices in what I teach and in what I do as a PI.
Thank you. Your Honor, I have no objection to this witness being an expert in the fields of CSR as well as cell tower analysis. However, I do object to this witness being tendered as an expert in the field of police practices, as their only experience in regards to police practices was a 9-month-long experience from over 15 years ago. And I'd like to note that past tendering as an expert in these regards hold no weight for today's trial.
All right, thank you. Any reply, counsel?
Yes, Your Honor. Under Rule 702, the witness in question only requires education, which she has because of her multiple degrees, experience or knowledge. She has all 3 in practices. Also, it is very relevant to this trial because police practices is reviewing the police's work and giving her opinion and her testimony, which is necessary for her as a PI.
All right, thank you. The court will admit and allow this expert to testify as an expert in the fields requested. Again, it's up to the jury to decide what weight to give to each and every answer.
Yes, Your Honor.
Thank you.
What do you normally do on a case like this?
I look over the police work and their investigations and the physical evidence, and I draw my own conclusions from all of it.
Is it necessary for you to visit the crime scene?
No, I am an expert in police practices. However, I do not do the police's job for them. I only study their practices and investigation. However, by the time I was involved, the crime scene had already been cleaned up. So even if it was my job, I wouldn't have been able to do it. I was, however, able to find another potential suspect, Blair Rollins.
Go ahead.
Your Honor, this witness's testimony is going outside the scope of the question asked.
Would you repeat the question one more time, counsel?
Was it necessary for her to visit the crime scene?
Overruled. You can answer.
No, it was not. And I was, after looking over all of the investigations, able to find another potential suspect, Blair Rollins, whom the police did not even consider.
Great. And who is Blair Rollins?
Blair Rollins is another student at Colorado High School.
Why is he another potential suspect?
Jonathan Rollins, Blair's father, was convicted after his trial, which Mackenzie Brackman was his lawyer for. Blair disappeared right after the murder of Mackenzie Brackman, and Blair is the same size of both Avery and Brackman, making it difficult to decipher who is who from the ring videos we have in evidence.
Your Honor, permission to share my screen.
Yes.
I'm now showing you what has been marked as Exhibit 20. Can you verify as to whether or not this is your, or do you recall this document?
Yes, it is my report.
And was this document prepared in the ordinary scope of your business?
Yes, I create a report like this for each case I work on.
And where are documents like this stored and retrieved from after they're prepared?
They're stored and retrieved from my place of business.
When would this document have been made?
Right after the murder of Mackenzie Brackman and added to throughout the course of my investigation.
Your Honor, I move to admit Exhibit 20 into evidence.
Any objection?
Yes, Your Honor, I have three. I object on the grounds of hearsay, cumulative, as well as best evidence.
All right, any reply, counsel?
I will take them one at a time.
Please.
Number one, for hearsay, under Rule 803, subsection 6, this is a business record, so that is an exception to hearsay, and it is not hearsay. Cumulative, it simply is not. It is just her experience, and it details every single piece of data that she recorded. So it is just her investigation. And I'm sorry, can you please repeat the third one?
Yes, the final one was best evidence under Rule 1002. I believe if you look at page 3 of this exhibit, there is an image of a knife. Now, best evidence under 1002 is requirements of the original. This image of the knife is in fact another exhibit, I believe Exhibit 21. Now, I'd ask that if the cumulative objection, which I would still like to respond to, is overruled, that they admit Exhibit 21 prior to the admittance of this exhibit.
Your Honor, on that regard, I can say that it is fine. We will not be touching base on the knife part. So since he's very concerned about the knife part of this exhibit, that is fine. We will redact it from this report. And if you could please elaborate on the cumulative.
Yes, of course. Under Rule 703, an expert witness is able to testify as to documents that might not regularly be admitted into evidence. This is Professor Van Owen's summation of what occurred in her theory. Now, Professor Van Owen is perfectly capable to testify as to the contents, and it would simply be cumulative evidence, and it would mislead the jury. And quite honestly, it is unnecessary to be admitted, as Professor Van Owen is perfectly capable to testify as to the contents of this exhibit.
The court feels that the objection is appropriate and the objection will be sustained. If you want to direct her attention to any of the document, you can certainly do that, but it's not admitted.
Okay. Where was Ms. Becker's phone on March 6, 2020?
As described in my report, the cell tower nearest to Brackman's house picked up signals from Ms. Becker's phone. It connected to the closest third of that tower to Brackman's house. However, we do not know what area inside that sector the calls were coming from.
Excuse me. Oh, never mind, Your Honor.
Yeah. Thank you.
Was this phone definitely at or near Mr. Brackman's residence?
There is absolutely no way to know that for sure. As stated in my report again, the arc of that sector is 12.6 miles long, and the area that sector covers is approximately 38 square miles.
Does this mean that Avery Becker was at or near Mr. Brackman's residence?
No, as I said before, the phone itself could be anywhere within those 38 square miles. And as I received in my investigation and is detailed in my reports, Avery states that she did not have her phone on her at this time, so it does not locate her phone.
Great. Now moving on to the witnesses. Why did you try and interview the prosecution's witness, Alex Cifuentes?
I was simply doing my due diligence as a good expert. A good investigator looks at both sides, and as my job, I need to look at all possibilities, and the prosecution's key witness is absolutely essential in drawing conclusions.
And what information did you get regarding Alex?
I got no information from Alex Cifuentes specifically. However, I did learn that he was friends with Blair Rollins, and I uncovered some screenshots that could possibly be forged that were given to Detective Markowitz by Cifuentes.
And why do you believe that the screenshots may not be accurate?
Since Detective Markowitz did not ask for Cifuentes' phone to be put into physical evidence, there's absolutely no way that we can know that those screenshots are 100% accurate. And it seems a little bit suspicious that Alex did not bring his phone with him, considering Markowitz himself believes that they're attached to every teenager.
And what is your opinion on the prosecution's crime scene reconstruction?
I believe it was.
Excuse me, counsel, could you repeat that question? It's very hard to hear you for some reason.
Okay, I'm sorry.
That's all right.
What is your opinion on the prosecution's crime scene reconstruction?
I believe that the crime scene reconstruction done by the prosecution was very rushed. First off, Kyle Cusack mentions the scuff marks on the floor, which cannot be carbon dated and can be made at any point prior to the murder. I'm sure many of us have scuff marks by our back doors at this very moment. And the doorbell could have possibly alerted Mackenzie Brackman of the intruder. However, if his volume was off, the ringer was off, or he simply did not have the alerts turned on, there's no way to say that for sure. However, this does not even matter because the prosecution has not given sufficient evidence to even say that Avery Becker was at the scene of the crime.
And what are your thoughts on the police's cell tower investigation?
Again, very, very rushed. They did not obtain cell phone data from anyone but Avery Becker's phone. They didn't receive anything from Tyler Perkins or Mackenzie Brackman. They also only obtained records of a limited time frame solely from the day of the murder. So we don't know where Avery Becker's phone was prior to the murder or afterwards.
And in your witness statement, you called the prosecution's investigation sloppy. What is your reasoning for this statement?
Based off of their investigations, I believe that they came to the easy conclusion. They solely relied on the evidence that would point to Avery Becker, and any evidence that came up that did not support their conclusion, they simply set aside.
Finally, what is your opinion on the defendant?
Based on the lack of evidence, I don't believe that we have enough to say that Avery Becker committed this murder.
Thank you. No further questions, Your Honor.
All right, thank you. Cross-examination.
Yes, Your Honor. May I proceed?
Please.
Now, Professor Van Owen, one of the reasons you quit the police force is because you became disillusioned with it,
Yes.
because of an incident in which you were sued, correct?
Yes, there was an incident.
And since that time, you consider yourself to be a bit of a crusader for social justice.
A bit. I do my part.
And that's what you teach, right? Social justice.
I teach police practices in criminal justice.
My apologies. You just testified that you've been endorsed as an expert in court 25 times and consulted in 100 different cases. Is that correct?
Yes, I have.
And all of these times have been for the defense.
Yes, not necessarily by choice. The
And-
defense has been the only people who ask for my services.
And in each of these 100 or more cases where you consulted for the defense, you're paid for your opinions, correct?
Yes, it's my job. I have to put food on my table somehow.
Between $6,000 and $10,000 per case, correct?
About.
Isn't it true that you were retained to review the police investigation for your personal investigation?
Yes, my conclusions are drawn from police investigations.
And your job was to find something wrong.
My job was to make sure that nothing was overlooked.
You didn't do your own investigation, did you, of the crime scene?
No, again, it is not my job. I'm not a police officer.
I didn't ask if it was your job. I simply asked if it was done.
No, like I said before, it had already been cleaned up, so it wasn't even possible.
So you were unable to visit the scene of the crime,
Correct.
unable to take any pictures on the scene.
Correct. However, I did receive the pictures that had already been taken from the crime scene.
Thank you. And you were unable to view Mackenzie Brackman's body, correct?
Correct.
But Detective Markowitz did, didn't he?
He looked at it. I wouldn't say he did a thorough investigation of the body itself.
And Kyle Kuzak did as well, correct?
Yes, he also looked at it briefly.
Now, I'd like to talk about Blair Rollins. You reviewed the audio tape from the trial of Jonathan Rollins, correct?
Yes, I did.
And the speaker was Jonathan Rollins himself, not Blair Rollins, correct?
Correct.
And he made a statement towards Brackman as he was being escorted to jail.
Objection, Your Honor. I would like my co-counsel to please submit the piece of evidence or submit the audio recording into evidence before discussing it with the witness.
May I respond, Your Honor?
Sure.
Your Honor, under Rule 703, this expert witness is able to testify as to evidence that is not admitted into evidence. Therefore, this testimony is admissible in the court today.
All right, the objection. Go ahead, counsel, briefly.
Again, under Rule 703, you are right, she is allowed to testify, but because the probative value of this piece of evidence does not weigh its prejudicial value on the jury, she's not able to testify.
All right, I'll allow the question and answer, and again, the jury will be allowed to put at whatever weight they determine is appropriate. But you can proceed and answer the question.
Thank you, Your Honor. In this audio file where you drew motive for Blair Rollins, this was a threat made by Jonathan Rollins, correct?
Yes, but it is still relevant due to family ties.
It wasn't Blair Rollins who made the threat, was it?
No, it was his father, but again, still relevant due to family ties.
And nowhere in your statement did you say you reviewed any videotapes, correct?
It was not a videotape, it was an audio recording.
Yes, because there was no videos. So you didn't personally observe Blair Rollins in the courtroom, did you?
No, I did not.
So you have no personal knowledge about whether Blair Rollins heard the statement made by Jonathan Rollins to Mackenzie Brackman.
Due to family ties, I would assume he
I
knew
didn't
that
ask you to
his.
make an assumption. I asked based on your own personal observations. Did you view Blair Rollins in the courtroom with Jonathan Rollins?
No, however, I know that he knows his father was convicted at the trial.
I understand that. However, you didn't personally observe Blair Rowlands present in the courtroom when this statement was made. Yes or no?
No, I did not.
No further questions, Your Honor.
All right, thank you. Any redirect briefly?
A brief one. You do get paid to testify on the behalf of Avery Becker,
Yes, I do.
and you got paid for this investigation,
Yes,
but you still took the same oath.
correct.
So regardless of whether or not you got paid or how much you got paid, you still took the same oath and you still will tell the truth, no matter what.
Objection leading.
I can rephrase, Your Honor.
Please. Yeah, go ahead.
Because you took the same oath, do you agree that the amount that you got paid does not matter?
Objection, Your Honor. This question is still leading.
All right. Objections overruled. You can answer.
I do not give my opinions or base my truth off of the amount I am paid. It's simply my job, and all the money does is decide whether I get to eat that month or not.
Any further questions?
Further questions, Your Honor.
All right, thank you. And does the defense have any further witnesses to call?
Yes, Your Honor. The defense calls Avery Becker to the stand.
Okay. Do I see that person yet? Not yet.
I'm here, Your Honor.
Oh, okay. Hello. I just wanted to make sure you understand you're under the same oath that I provided to the other witnesses up to now. Is that right?
Yes,
And you'll comply with that same oath. Is that correct?
that is correct.
Okay. Thank you very much. Proceed.
Good morning. Could you introduce yourself to the court?
Hi, my name is Avery Becker, and I just graduated from Colorado High School.
Why are you here today, Ms. Becker?
I'm being wrongfully accused of murdering Mackenzie Brackman, my mock trial coach.
Could you tell us a bit about your involvement with mock trial?
Yeah, of course. I loved mock trial. I was on the team at Colorado High School, and it was awesome. And Coach Brackman was the coach.
Sounds like a lot of fun. Could you tell us why you joined in the first place?
I joined with my best friend, Taylor. We wanted to do it after school. It seemed like fun, and it certainly was.
Would you tell us a bit about your relationship with Taylor?
Taylor's awesome. He is my best friend.
Thank you. And what did you think of the coach, Mr. Brackman?
We fought all the time. I didn't like him, and he definitely made it clear that he didn't like me.
Why did you fight?
I prepared for mock trial in a different way than he would have liked me to. He preferred scripts, and I like to kind of feel the room a little bit more, and it worked for me. So I don't really know why he was always on my back about it.
Yeah, could you tell us a bit more about how you performed?
I was good at mock trial. I actually just at the regional tournament, I won the best attorney award and the best closing award. So I did really well doing it my own way.
And were you in mock trial till the end of high school?
No, actually I wasn't. I was asked to leave the team after an incident.
Could you tell us a bit about that incident?
Yeah, it's actually really embarrassing. Well, it happened after the regional tournament, and I was standing near a whiteboard about to write all the great things that I had done, which were a lot. I mean, I got those 2 awards, like I mentioned, and then Brackman came in.
And what did he say?
He started going off on me, and it was horrible. He said that I was lazy and that I wasn't going to do as well at state because of my lack of preparation, that I didn't deserve all the awards that I won. It was really embarrassing. He said all that stuff in front of all my friends. I was very upset.
That must have been tough. How did you respond?
Well, I was upset and embarrassed. I didn't want to be there anymore, so I stormed outside. And then I saw his car.
Did you do anything to the car?
I did. Unfortunately, I made a really big mistake. I took the marker that I'd been standing near the whiteboard with, and I had it in my hand still. I drew Worst Attorney Award on the hood of his car.
And how did Mr. Brackman respond?
He came outside and he actually didn't see it at first, but then as soon as he saw it, he snapped. It seemed he started yelling at me again, and that's when he kicked me off of the team.
What did losing mock trial mean to you?
Everything. I loved mock trial. It was such a huge part of my life in high school. So being asked to leave the team in such a dramatic way for just this thing that I regretted after so much was really hard for me.
Could you please tell us how you felt after riding on the car?
I was still upset, but after calming down, I feel nothing but regret for that huge mistake that I made. I wish I never did that. I wish I could make it up to Mr. Brackman.
Were you able to apologize to your coach?
No, and I so deeply wanted to. I actually went to his office the next day trying to apologize to him in person. I was told that he was busy. He didn't want to see me. So I texted him instead, said that I was willing to work all summer to fix his car, scrub it off myself, whatever needed to be done to make it up to him. I wanted to fix our relationship and show him how sorry I was.
Thank you, Avery. Now, let's move a couple days forward. Where were you on March 5th, the day before Mr. Brackman's death?
I was with Taylor. We went to the mall and the Fry Shack, which was actually really embarrassing because we saw the entire mock trial team there.
Why was it so embarrassing?
Well, the day before, I was just asked to leave the team after making the biggest mistake of my life. And everyone was there, and they were all hanging out where we used to hang out. And Alex Cifuentes was there, which made it even worse.
Why did seeing Alex Cifuentes make the whole situation that much worse?
Well, Alex and I were rivals on the team. He was on the team with me and often tried to take my spot. And then when I left the team after Mr. Brackman asked me to leave, he was the best on the team, and he had taken my spot, and he was hanging out with all my friends, doing all the things that we always did as a team, and I didn't get to be a part of that. So I was really overwhelmed and went to the bathroom for a minute.
Would you ever ask Alex for help?
Ask my mock trial rival for help. No, that's a joke. I would never ask him for help.
Thank you. So after you went to the bathroom, what did you do?
I was overwhelmed with the whole experience. So Taylor and I left. I was really frazzled and distracted after that. So I wanted to get out of there as soon as possible.
And do you remember taking your phone with you?
No, I actually lost my phone on the night of the 5th.
Now, what were you doing the next day, March 6th?
I was looking for my phone that I lost the previous night.
How did you realize you lost it?
Taylor and I realized that we didn't have it. So we started retracing our steps, went to the mall, called, texted it all day. We were looking all day, but we still never found it.
Avery, Miss Becker, how did you feel upon learning of your former coach's death?
I was devastated. Mock trial was such a huge part of my life, and Coach Brackman was a really big part of that as well. We didn't always get along, but I feel like he deserved an apology, and I really wanted to tell him how sorry I was and how much I regretted, how much we fought, me drawing on his car. It was really unfortunate to hear that someone had killed him and that he would never get to hear that from me.
Avery, Miss Becker, have you ever been to Mr. Brackman's home?
No, I don't even know where he lives.
And I hate to ask you this, but did you have anything to do at all with your former mock trial coach's death?
No, I had absolutely nothing to do with the murder of Coach Brackman.
Thank you, Your Honor. I have no further questions for this witness at this time.
Okay, thank you. Cross-examination?
Yes, Your Honor. Now, Miss Becker, you loved mock trial, didn't you?
I did. It was everything to me.
And you thought you were the best on the team.
The awards to prove it, yeah.
Yeah, and Mr. Brackman stood in your way, didn't he?
He tried to, which is why we fought, but yeah, it was difficult.
And you thought he hated you.
He made no effort in trying to hide that.
He called you lazy.
He did.
He discredited your work.
In front of all of my friends, yeah.
And he even moved you down to the B team.
He did.
A team that you thought were losers.
I mean, it's no secret that A team is ranked higher than B team.
And after all of this and all of your accomplishments, he said you only won because of your looks, didn't he?
He tried to discredit me, like you said.
And so you were angry, weren't you?
Embarrassed, yeah. I was upset.
You were so angry that you took a marker, correct?
I already had one in my hand.
And you went outside and vandalized his car, didn't you?
I did, and I really, really regret doing it. I wish I could tell him how sorry I was.
And he kicked you off the team, didn't he?
Unfortunately, he did.
A team that meant everything to you.
It was upsetting, yes.
So you went home and talked to your mother, correct?
I did, yeah.
You told your mother that you would get back at Mr. Brackman if it was the last thing you did. Didn't you say that?
I mean, I was embarrassed and upset. Heat of the moment. I vent, get over it, feel better. I regret saying that. I didn't mean it.
And what was the answer? Oh,
Sorry?
what was the answer to the question?
I did say that, yes,
Thank
but
you.
I didn't.
And did you see Exhibit 14 today?
I don't recall what 14 was.
Can we please pull up Exhibit 14? Now, the last text messages in this, or excuse me, the top name says Avery Becker, doesn't it?
Does appear so, but it must be a different Avery Becker because I don't recognize those.
But the last two texts say, I'm going to wait until he's at work, then break in and trash it. That will show him, doesn't it?
Yes, it does appear to say that.
And so these text messages mirror what you told your mother, don't they?
They do, but what I said to my mom was a cliche. I was venting and quickly, after calming down a bit, did not mean what I told her.
I'm sorry, Miss Becker, that's not what I asked. These text messages, yes or no, mirror what you told your mother.
Yeah, they do.
So you sent these text messages, didn't you?
No, I did not send those text messages.
And so you claim on direct that you lost your phone on March 5th.
I did lose my phone on the 5th.
But your phone is very important to you, isn't it?
Yeah, I like being on my phone, yeah.
You joined mock trial to be on your phone longer.
With my friend, yeah.
And you turn your phone into your mother every night, don't you?
I do.
And so on March 5th, you didn't notice you lost your phone when you turned it into your mother?
No, I didn't.
And you didn't notice until the next morning, even though you were supposed to turn your phone in that night.
I was really frazzled by the events of the 5th.
So you never lost your phone, did you?
I lost my phone on the night of the 5th, yes.
And so on March 6th, you were with Mr. Perkins all day, weren't you?
Yes, looking for my phone.
Mr. Perkins is your best friend, isn't he?
Yeah, he's awesome. Taylor and I are super close.
He joined mock trial for you.
We wanted to do it together. It seemed like fun.
And he quit mock trial so that you could be on the A team, didn't he?
It was more for the team, but you could say that, yes.
And so it's fair to say that he would do a lot for you.
I don't know. We're friends. I think that we would do things for each other, yes.
Best friends.
We are close friends, yes. Best friends.
And so the only person who knows where you were on March 6th is your lifelong best friend, Mr. Perkins.
Yeah.
No further questions, Your Honor.
All right, any redirect?
Yes, Your Honor, if I may perform a brief redirect.
Okay. Proceed.
Ms. Becker, when you told your mom you would get back at Mr. Brackman no matter what, did you mean it?
Maybe in the moment, but I was really upset and embarrassed about what just happened at practice. And as soon as I calmed down, I definitely didn't mean it. And I really regretted riding on the car and saying that to her. The whole day was full of a lot of regrets for me.
Thank you, Ms. Becker. And is that phrase specific to you?
No, I've heard so many people saying that they're going to get back at their boss or whatever, and you don't see people going around getting each other. No, this is a cliche.
Ms. Becker, do you usually interact with your phone after dinner?
No, it's not something that I normally do, so no.
Thank you, Your Honor. I have no further questions for this witness at this time.
Thank you very much. Does the defense have any further witnesses?
Yes, Your Honor. The defense calls Mr. Taylor Perkins to the stand.
Okay. And Mr. Perkins, you heard the oath that I've administered to the other witnesses up until now, is that right?
Yes, Your Honor.
And you understand that that would apply to you as well, is that right?
Yes, Your Honor.
Yeah, thank you very much. Proceed.
Good morning, sir. Could you please introduce yourself to the jury and spell your last name for the record?
Hello, everyone. My name is Taylor Perkins. It's spelled Perkins. And I am a current student at CU Boulder, as well as a former student at CHS and the CHS mock trial team.
And how would you describe your relationship with Avery Becker?
Avery and I were best friends. I mean, we've been together. We've been best friends for the longest of times. And she's actually one of the reasons why I joined mock trial in the first place.
How do you spend time with Avery?
If we're not talking about mock trial, or if we're not working on mock trial, we would just go to the mall together, play video games, just hang out like high school stuff.
And how long were you on the mock trial team with Avery?
I was on the team with her for around 3.5 years.
How well did you know the rest of the mock trial team?
I knew them pretty well. I mean, I could definitely hold a conversation with each one of them.
And how well did you know Mr. Brackman?
I knew him pretty well, as much as a student could get to know a teacher.
Thank you, sir. I'd now like us to talk a little bit more about what you have personally observed. What did you personally observe about the relationship between Mr. Brackman and Avery?
Well, the two definitely had differences in work style. I think Avery's the type of person that inspiration came to her spontaneously. And Brackman was different. And I don't think Coach Brackman really respected her in that manner. And so the relationship was a little strained at times because of this difference in work style.
That you know of, did these feuds ever reach a boiling point?
A few times. I mean, there was this one time that Coach Brackman actually demoted her to the B team. And then later on in the season, he actually decided to bump her off the team entirely.
Were you there when Avery got permanently kicked off the team?
No, I was not.
How do you know about it?
Avery actually told me a little bit later. She said that she made this terrible
Your Honor?
mistake.
Yes, go ahead.
Speculation and hearsay.
Okay, response.
May I respond to them one at a time, Your Honor?
I'm sorry, would you repeat that, please?
May I respond to them one at a time, Your Honor?
Yes, please, please.
For the first one, speculation, it's already been established that Mr. Perkins is Avery's best friend and would, of course, have interactions with her. And these interactions would often be about what has happened in Ms. Becker's life. So he's not speculating about this happening. Also, for the hearsay objection, this isn't hearsay because it's not being offered to prove the truth of the matter asserted. It's actually being offered to prove the effect on the listener and the effect on the mock trial team.
Your Honor, if I may. Your Honor, may I respond?
Yes, please.
Thank you, Your Honor. Speculation, on the account of speculation, this witness was not at the mock trial practice in question. He did not see what happened. Therefore, he cannot testify under Rule 701. He did not personally observe what he's going to testify about. On hearsay, if it is not being used the truth of the matter asserted, then I ask that they strictly reserve it to the effect on the listener and how Mr. Perkins reacted to it and how the mock trial team reacted, and not testify anything about what actually happened.
All right, thank you. Counsel, since you've used the phrase using it not for the matter or truth of the matter asserted, what purpose are you using it for?
Your Honor, we are trying to establish that Avery getting kicked off the team was of a negative effect for the mock trial team. And that's why Mr. Perkins then stepped down from the team, because he no longer wanted to be on the team if Avery was not on it. May I also respond to one point that opposing counsel made?
Briefly.
They said that he cannot testify about this occurrence. I actually haven't asked him any questions about this occurrence, so I would like to ask opposing counsel why they still think that that's a speculation objection.
All right, so the objection is sustained and overruled to some extent. So what I will have you do is rephrase the question so that it is not hearsay and in the way that you intended it to be asked. Does that make sense?
Yes, Your Honor. Mr. Perkins, how did you feel after Avery was kicked off the mock trial team permanently?
I mean, I felt really devastated for her. The fact that she spent so much time on this team and the fact that she was being kicked off, it was really devastating for her. And I felt really bad for her that one mistake just decided her entire future.
And how did she attempt to get back on the team?
She actually texted a few people on the team as well as set up a meeting with Coach Brackman, but that meeting didn't actually pan out. But she definitely tried to text a lot of people on the team, maybe even Alex Fuentes, but that would be a really last resort.
You know Alex Fuentes?
Yes, I do. He's this really stuck-up kid on the team, always kissing up to Brackman, always trying to be nice to us, but he was really ingenuine and it was really annoying.
And do you know if Avery texted Alex?
It's definitely a possibility. I'm not 100% sure, but it would definitely be our last resort. Those two were definitely not friends. They were really not good friends at all.
Could you expand on why it would be a last resort?
Well, they never really got they never got along on the team. They were just different people. And the fact that there's text messages out there is really astounding to me, that people are saying that they're texting each other. That would just be absurd to me.
All right, now let's move on to the events being discussed here. What did you do the afternoon of March 5th?
On March 5th, that was actually the day that Avery had her meeting with Coach Brackman, but since that didn't pan out, he didn't really want to talk to her. We hung out after school that day. So we went to the mall, we went to the Fry Shack, which was weird because we ran into the mock trial team that day.
And who did you see on the mock trial team?
We saw a bunch of people on the A team as well as Alex Fuentes, which was really awkward. And I think Avery seeing them was really upset, so she stormed off to the bathroom.
What did you see Alex doing?
He was trying to talk to us, trying to kiss up to us, saying, "Oh, Brackman is really insincere." And it was just really annoying. It was so aggravating that day.
And what did you and Alex talk about?
Well, we talked about how he really wished we were still on the team, but however, we should still move on. And it was just crazy that he was talking about Brackman, even though he always kissed up to him. It was really insincere.
Mr. Perkins, what were you doing on March 6th?
On March 6th, we actually spent the entire day looking for the phone because Avery actually picked me up that morning, but before that I was texting her and calling her and she wouldn't pick up. And so when I got into the car, we found out her phone was missing. And so we spent the day looking for it.
What did you do to look for her phone?
We retraced our steps the day before. We went to the Fry Shack, we went to the mall, then we went to the Fry Shack again, and we saw the mock trial team again, which was weird.
And what happened when you two were at the Fry Shack on March 6th?
We saw the mock trial team, as I said, and which was really weird because we went there at a time where they should have been at practice, but they said that Coach Brackman actually hadn't shown up, which was really weird. And then later that night, we found out that Coach Brackman was dead.
I'm sorry, Mr. Perkins, we can move on from that. I can see this is hard for you. Were you with Avery the whole afternoon of March 6th?
Yes, I was the entire afternoon looking for the phone.
And is there any way Avery could have left you and gone to Mr. Brackman's house?
No, there isn't. There is no way she could have left me. And the fact that she might go to jail for something that she didn't do, I'm sorry. This is, it just really upsets me.
Quite all right, Mr. Perkins. Were you ever interviewed by a Detective Markowitz?
No, I was not.
And was your phone ever requested by the police for searching?
No, it was not.
Mr. Perkins, what did you promise to in this courtroom?
I promised today to tell the truth about what happened.
And would you break that oath, even for your best friend?
No, I wouldn't. This is way too serious. Someone died. That's horrible.
Thank you, Mr. Perkins. Your Honor, I have no further questions for this witness at this time.
Okay, thank you very much. Cross-examination.
Yes, Your Honor. So, Mr. Perkins, you and Ms. Becker were very close, correct?
Yes, we were best friends. We always have been, like, we've always got along really well.
Right, and if she was in trouble, you would want to help her out.
Yeah, I would always try to help her out in some ways, yeah.
In fact, on multiple occasions, you've made sacrifices for Ms. Becker, correct?
Can you specify the multiple times? I'm sorry.
Of course. So once, you gave up your spot on the mock trial team so she could get back on, correct? And
yes,
then,
that's.
Thank you, Mr. Perkins.
Sorry.
No worries. And then also, you gave up your entire day on a whim just to help her find her phone. Isn't that correct?
That's correct. But we actually took our lit exam earlier that week, and that day was pretty dry. I mean, we didn't really have any important classes to go to. So yeah, we skipped that day.
So on March 5th, you were with the defendant at the Fry Shack, correct?
On March 5th, yes, that evening.
And so the defendant had her phone with her, right?
Yes, she did for a little bit. And then we left, and I think I remember her leaving her phone on the table.
That's all right. Thank you. So she was very attached to her phone, wasn't she?
She usually was, but that night was super emotional for her. So I wouldn't be surprised if she misplaced it that evening.
However, in your witness statement, you did describe her phone as her third kidney, correct?
Yes, but once again, that evening was so emotional for her that she might have misplaced it, yes.
In fact, that evening, she forgot it once at the Fry Shack table and again when you actually left the Fry Shack. Isn't that correct?
Yeah, that is correct.
So after you two left the Fry Shack, you guys went to the mall.
Yes, that is correct. We spent the time there just playing video games on my phone, and then we also just went to some stores, yeah.
So the entire time you were at the mall, you never saw Miss Becker take her phone out to check Snapchat, text her friends, or call her mom?
Objection asked and answered, Your Honor. Defendant has
Overruled, you can answer.
No, I did not. We basically spent most of our time just walking in stores doing high school stuff.
Right, because if Miss Becker had tried to do any of those things, she would have noticed that her phone was missing. Isn't that right?
That is correct, but I think she was really emotional after seeing the A-team, after she spent so much time and effort trying to get back on the team.
Mr. Perkins, it's your story that Miss Becker didn't notice that her phone was missing when you guys left the Fry Shack, when you spent your day at the mall, and when she went home. That's your story?
Yes, that's correct.
And then the next day, Miss Becker woke up, she got ready for school, and she drove to meet you. And she still didn't notice her phone was missing until you told her. Isn't that correct?
Yes, that's correct. I can't really talk about what she was feeling, but yeah, she didn't notice until we brought it up in the car.
So that day on March 6th, you drove around for hours looking for her phone, correct?
Yeah, we spent the entire day retracing our steps the day before, and we tried to do everything. I was calling it, I was texting it, seeing if we could hear it anywhere. Yeah.
Thank you, Mr. Perkins. So you went through all those steps, but the iCloud website could have easily tracked it.
Yes, but at the time I actually have an Android and I didn't think that we could use an Android to locate it like an Apple device, but I guess we can use the website, but at the time we didn't know we could use that.
So at the time, you didn't know that you could use the iCloud website, but you did remember it?
That's correct because I had an Android and we didn't think that Androids could use Find My iPhone
Mr.
for an
Perkins,
Apple.
do you recall giving a witness statement in this case?
Yes, I do.
And do you recall saying, I have an Android, but we didn't remember that you could use the iCloud website? So you didn't remember, but now you're stating that you did remember, but you thought that because you had an Android, you couldn't use it.
I'm not saying that I did remember. I'm saying I remember right now that we can use the website, but at the time I had an Android once again, and I did not know that we could use the website to locate the phone.
I'll move on. So you stated in your testimony that you and Ms. Becker were nowhere near Coach Brackman's house that day, correct?
I mean, we were at the mall and we were at the Fry Shack, and I don't really know where Coach Brackman lives, but I don't think he lives near a mall or even the Fry Shack.
Right, because so if you don't know where he lives, then you wouldn't know if you were near his house or not, correct?
That's correct, but we didn't really go into any neighborhoods. We went to the mall and we went to the Fry Shack.
Mr. Perkins, were you at Coach Brackman's house on March 6th?
No, I was not.
And are you sure about that?
Yes, I'm sure. I would have remembered if I went to someone's house that day.
Do you recall giving a witness statement in this case?
Once again, yes, I do.
And do you remember saying, it was creepy to think about Brackman bleeding on his porch?
Yes, I do. Yes, I do remember saying that. I was referring to when
the unknown 911 caller also said that Coach Brackman was on his porch, correct?
Lack of personal knowledge.
Your Honor, if I may.
Please.
The witnesses are not sequestered, and Mr. Detective Markowitz testified to this 911 call. Therefore, the witness does have personal knowledge to answer this question.
And any reply?
No, Your Honor, no response, but I would also ask that the attorney don't ask any questions of Mr. Perkins attesting to what happened before or after this 911 call.
All right, I'll overrule the objection. You can answer.
Your Honor, to clarify, may I continue to ask questions about this 911 call?
Well, depending upon the purpose for which you're asking, yes.
Of course, Your Honor. So, Mr. Perkins, the 911 call also said that Coach Brackman was on his porch, correct?
I don't know the exact words that this 911 caller said, but yeah, I mean, I assume that he said someone was dead.
So you and this unknown 911 caller have identical incorrect accounts of where Coach Brackman was found.
I mean, I guess you could say that, but once again, I'm not really sure what's this 911 caller said.
No further questions, Your Honor.
Okay, thank you. Any further witnesses on behalf of the defense?
No, Your Honor, but may I perform a brief redirect of Mr. Perkins?
Yeah, very brief though.
Very brief. Mr. Perkins, just to clarify, you did not go into any residential neighborhoods that day, the day of March 6th?
No, I did not. We just went to the mall and to the Fry Shack, everywhere we went the day before.
And you were with Ms. Becker the whole time?
Yes, I was.
And do you know where Mr. Brackman lives?
No, I have no idea where he lives.
Thank you, Mr. Perkins. Your Honor, I have no further questions.
All right, thank you. Any further witnesses on behalf of the defense?
No, Your Honor, we have no further witnesses. The defense rests.
All right, the defense rested. Parties ready then for closing argument.
Yes, Your Honor, the prosecution is ready to proceed.
And defense counsel, are you ready to proceed after the prosecution's counsel?
Yes, Your Honor, I'm prepared to proceed.
Okay, thank you very much. All right, counsel for the prosecution. As you know, you can save some time for rebuttal as long as it's within the scope of what was argued by the defense, your understanding, right?
Yes, Your Honor.
Okay, proceed.
Thank you for your time and attention during the trial today. Everyone has a breaking point, and Avery Becker is no exception. After an endless barrage of criticism, insults, hatred, and a demotion from her mock trial coach, Mackenzie Brackman, Avery Becker hit her breaking point. And that is why we are here today. And in her own words, she would get back at Mr. Brackman if it was the last thing she did. Now, the evidence and testimony presented today has shown that Ms. Becker, while attempting to vandalize Mr. Brackman's house, was surprised by his presence, and in a fit of rage and fury, fought him for control of his knife, consequently stabbing him in the back. The defendant has been charged with 2 crimes, first-degree murder and second-degree burglary. To be guilty of first-degree murder, the defendant must have knowingly and unlawfully broken into the home of Mr. Brackman and during that invasion killed him. To be guilty of second-degree burglary, the defendant must have knowingly broken into this residence with the intent to vandalize. Now, the elements of these crimes have been proven beyond a reasonable doubt, but let's walk through them. First, Ms. Becker had clear motive to break into Mr. Brackman's house. You heard about how mock trial was everything to her, how she hoped to win awards at state, but Mr. Brackman stood in her way. You heard about their tumultuous relationship, the fights and the arguments that led up to her demotion to the B team, and how all of this culminated in one final fight, where she took a Sharpie and vandalized his car. She snapped. And when she realized that when she was finally kicked off the team, she decided to get revenge. She hit her breaking point. Now, with that motive in mind, let's look at intent. Ms. Becker clearly intended to break into and vandalize Mr. Brackman's home. First, she talked to her mother, where she stated that she would get back at Mr. Brackman if it was the last thing she did. Then, she texted Mr. Cifuentes in a final effort to get back on the team, again stating that she would wait until Mr. Brackman was at work, then break into his home and trash it. These stories are the same. And so with that in mind, Ms. Becker skipped school on March 6th, established a false alibi with her loyal best friend, Mr. Perkins, and killed Mr. Brackman. Now let's talk about this alibi. You heard about the unwavering friendship between Ms. Perkins and Mr. Perkins and Ms. Becker. How Mr. Perkins joined mock trial, quit mock trial, and would have done anything for the defendant. This alibi is biased and not credible. And the story about Ms. Becker losing her phone, a phone that was like her third kidney, a phone that she turned in every night, but still didn't know it was missing, well, this story is not credible either. And so with these in mind, let's look at means. Ms. Becker clearly had the means to break into and vandalize Mr. Brackman's home. You heard from Detective Markowitz and Kyle Cusack, who explained that all the evidence points to Ms. Becker as the murderer. Detective Markowitz explained how the call detail records put Ms. Becker at the crime scene at the time of the murder. Now, the defense wants you to believe that Ms. Becker made a stupid teenage mistake, but they fail to acknowledge the anger that lies dormant below the surface. Ms. Van Owens wants you to believe that this was a flawed investigation. However, not one of her opinions are based on her own personal observations. Instead, she chose to make her opinions based on bias and criticism of the prosecution. And no matter what the defense may try to suggest, there's absolutely no evidence that Blair Rollins was involved. Now, as you deliberate today, I want you to think of Mr. Brackman, a man who spent his life fighting for justice, a man who taught others to fight for justice. Do not let justice fail him today. Ms. Becker hit her breaking point, and there must be consequences. The prosecution asked that you reach the only logical verdict: guilty. Thank you.
Very good. Thank you very much, counsel. Counsel for the defense, closing argument.
Yes, Your Honor. Members of the jury, what we see presented by the prosecution today isn't just an inexcusable accusation flung onto a teenager. It's an exhibition of laziness and sloppiness and a refusal to perform a responsible investigation. The police didn't seek the guilty party out. No. They sought Avery Becker, arresting her not because it was right, but because it was easy. There were multiple avenues that the authorities could have exhausted in their duties. They could have checked Alex Fuentes' phone to ensure the legitimacy of the supposed text message confession. Yet Detective Markowitz tries to explain away his decision by saying that screenshots were enough. And Detective Markowitz still could have interviewed Mr. Perkins to verify Ms. Becker's alibi for the time of the murder and that her phone had actually been lost. Yet they never even attempted to search Mr. Perkins's phone. They could have investigated the criminal former client of Mr. Brackman, Mr. Rollins, a man who, having been thrown in prison because of Mr. Brackman, surely has some motive worth investigating, particularly when his son wasn't seen at school. And what do we see the police do? Accuse someone who has already shown great remorse about her difficult relationship with Mr. Brackman, someone who tried to apologize profusely for her mistake with the car, someone who has an alibi for the time of the murder. And what have the all-assuming authorities done with this treasure trove of information? Nothing. They left it in the dust of their relentless pursuit of Avery Becker. And why did they come after her with such vigor? A tip from a student already jealous of Avery's success. And they didn't even bother to investigate Alex Cifuentes after receiving this tip. Surely an accusation of that nature merits some investigation, especially when there's clear friction between Mr. Cifuentes and Ms. Becker. Professor Van Owens has done more to uncover the truth of this case than the police ever cared to, tirelessly searching for evidence and following up on the loose ends that the police blatantly ignored. Had we seen that initiative from Detective Markowitz or Mr. Kuzak, we could have seen a completely different suspect on the witness stand today, and Avery Becker wouldn't have been traumatized by this cruel accusation. The prosecution wants you to believe that Avery Becker went from a moment of hot-headed vandalism to a planned and coordinated attack. But despite what they would have you believe, it's not a crime to get upset. It's not a crime to have emotions and to be human, especially when Ms. Becker tried to profusely apologize for her actions. And this does not mean that Ms. Becker is a murderer. We must ask ourselves, what have the police proved today? And what do they need to prove? They're obligated to prove beyond a reasonable doubt that Avery Becker went to Mr. Brackman's house with the intention of ransacking it. And at some point during the course of that suspected crime, Mr. Brackman was killed. And what can the prosecution say? Well, they can say that maybe Ms. Becker's phone could have possibly been near Mr. Brackman's house, a phone that two people testify wasn't even in her possession the day of the crime. We have text message printouts from a phone that wasn't even brought in to check the validity of these texts, a phone that has now been conveniently traded in. This is not proof beyond a reasonable doubt. This entire case is shrouded in speculation. Now, the prosecution asserts that we should be giving Mr. Brackman justice, and the defense wholeheartedly agrees with this. But this isn't justice. This entire investigation has been shrouded in a neglect for the actual facts of the crime. Mr. Kuzak says that he took the puzzle pieces together and formed that puzzle into the picture they now see. But to carry the metaphor, Detective Markowitz doused these puzzle pieces in gasoline and Mr. Kuzak lit the match. They did not care about the facts. They cared about an easy conclusion. They cared about getting to go home on the weekends. The police haven't proved that Ms. Becker broke into Mr. Brackman's house. They haven't even proved that she intended to. They have not proved that Ms. Becker was even near that house. They have not proved that Ms. Becker even had her phone. The police have proved nothing, let alone guilt beyond a reasonable doubt. The prosecution came to this conclusion not because it was right or just or doing Mr. Brackman a service, but because it was easy. See for yourself, members of the jury. Please understand that you must find Ms. Becker not guilty. Thank you.
Thank you very much, counsel. Timekeeper, I would say there's probably about a minute left for rebuttal. Ms. Seaman, you wish to make a brief rebuttal?
Yes, Your Honor. Sorry.
Okay. Go ahead.
The defense argues that this was a stupid teenage mistake. Was it a stupid teenage mistake when Miss Perkins allowed her bias to cloud her testimony? Was it a stupid mistake when Miss Van Owens allowed bias and baseless conclusions to cloud her opinions? Was it a stupid mistake when the defense tried to incriminate Blair Rollins, a student that has no evidence against him? Was it a stupid mistake when the defense tried to throw different pieces of evidence that had no relevance to this trial? The defense is right. It is not a crime to get upset, but it is a crime to get upset when you stab your mock trial coach in the back, as he had done to Ms. Perkins so many times before. She hit her breaking point. Find her guilty. Thank you.
All right, thank you very much. No further matters to come before the court. The court will now allow the jurors, in this case, the scoring panel, to complete their work, and then we'll have some opportunity briefly for some critique or questions and answers from the team. Excellent job by everybody, and we'll be in recess until that is finished.
You guys can start your feedback if you'd like. We have most of your score sheets.
All right, so any of the scoring judges, or I didn't know if they were finished or not. I didn't quite hear the last thing said.
Yes, we received all the score sheets, so they're all finished.
Okay, very good. If the scoring panel want to turn on your cameras. Who wants to go first on the scoring panel? Hello?
I'll just pick one of you if you want.
Please.
Jason, do you want to go first? Ooh, we can't hear you.
Yeah, are you unmuted?
Alan, do you want to start?
Sure. I thought this was really good. Both teams are really good. Witnesses on the defense side were fantastic. I thought cross-examinations all 6 of them were really good. Let me get some names here. Heidi, Morgan, Anna, and Leah. You guys are all super good, both sides, direct and cross. Slow down, all of you, a little bit. You're very good. Just make it better by going slower. Ms. Gillespie, that was the best witness performance I saw today. And I'll disclose to the panel, I might actually know Ms. Gillespie. I didn't realize that before we started. And if it's the same Paige Gillespie that I think I know, it's been about 10 or 12 years since I saw her, so probably not an issue. But if you want to score that, disqualify me, that's okay, because I don't want anyone to think that anything was improper there. But you did very well, Paige. Good job, guys. Objections, just a couple of constructive comments. Don't object if the evidence that you're seeking to not allow to be admitted is bad evidence. Object if it's not admissible. There's a difference between admissibility and credibility, and we saw that a lot today. If it's bad evidence, deal with it on cross. Don't worry about it on admissibility issues. And then on cross-examination, guys, you did a good job getting your answers, but it took you a couple of steps to get there. Ask the questions to get the answer you want on cross from the very beginning. And you don't have to argue with the witness, and you don't have to ask the judge to tell the witness to say yes or no. If you want a yes or no answer, ask a yes or no question and make the witness say yes or no. Good job. Very, very good job. Impressive, all of you.
Thanks, Alan. Who's next?
I can go quick. Like Alan said, I thought you guys all did a really great job. Everyone was really great at responding to objections, very calm and concise. On the openings, you both really could have pushed the burden of proof a little bit more. I heard you guys both kind of say oh, there won't be doubt or there will be some doubt, but you could have been a lot more clear cut of you have to prove beyond a reasonable doubt, and they won't prove beyond a reasonable doubt the issues in this case. On top of that, I was really impressed on the defense side, you guys doing questions with kind of not doing that classic correct or right at the end, which kind of can get redundant after a while. But when the witnesses are kind of not answering in a yes or no fashion, it sometimes is easy just to add that to the end to try to get a clear, this is a yes or no question. Overall, though, everyone did an amazing job. I thought you guys all had really strong performances, decent objections. And like I said, everyone was really good at responding to each other in clear and concise ways and not getting flustered, which was really amazing. So great job, guys.
And one more, right?
Yeah. Can you guys hear me now?
Yes, thank you.
Excellent. Yeah. So first of all, awesome job. I thought the closing statements were incredible. Miss Taylor, your tone of voice was really, really great and very, very powerful. The only thing that I would say is build on the theme a little bit more. It seemed like the opening statements brought out these themes of breaking point. It brought out the theme of just like any other teenager. I think that kind of got lost throughout the trial, and then it wasn't even touched on in the closing statement. So I think if you can kind of bring that full circle, it can help your argument a little bit as well. And then as far as I just wanted to comment on the cross-examinations. I thought the answers were good by the witnesses. If you're allowed to be kind of explaining your answers, that's great. The lawyers can kind of control the conversation a little bit more to kind of stop that from happening. Like she just said before me, you can add kind of those answers or the correct or yes or no at the end of the answers to kind of control that conversation a little bit better.
Okay. Just a couple from me. I was a practiced law for almost 50 years, and 20 of those were as a judge. And I thought both teams did a fantastic job. I'm very glad that I'm not on the scoring team or part of the scoring team because it would be very difficult for me to determine who had more points. But just a couple of things I would say to you is I thought both closings are really, really good. The Siemengers was very clear and concise. Ms. Taylor are the same. So I would just say on cross, little bit of disagreement maybe with Alan is that I think sometimes you do need to ask the court to instruct the witness to say or to answer the question, you know, without a whole bunch of extraneous stuff coming in. And for example, Mr. Holbrook, a great witness. I mean, you know, he's like every witness that we see in real court. You know, he wanted to go on, and as we did most of them. And you have the opportunity at times to say to the court, I would ask the court to direct the witness to answer the question and not go on and on. And sometimes having the court tell somebody or witness something is really effective in the middle of a trial. But in all, I mean, the directs were really pretty decent. And a couple of objections could have been in there about leading questions and so on. But I'm kind of with Alan, you deal with that in cross really than making a big deal about it during somebody's direct. But if this were not COVID and not online, I'm sure that everybody that either is in the gallery or on the scoring team and myself would be applauding all of you guys because you did a fantastic job. So virtual clapping, okay? All right, well, thanks guys. And we're, unless anybody has anything else they need, are we able now to leave the meeting? Ma'am? All clear? It sounds like it. So you're either welcome to hang around or you can leave the meeting, whatever you choose. And again, thanks very much.
Thank you,
Thank
Judge.
you to
Your
all
Honor.
our volunteers as well. And if you are doing another round, head back to the judge lounge for orientation again in your new assignment.
Thank you. And
Thank
bye-bye.
you, guys.
Thank you.
You're welcome.